I gave up bragging for Lent. Well, I'm trying. It's hard. I mean, put yourself in my shoes. Imagine coming to work every day with extraordinary people at our great law school, like Professor Joel Gora, like distinguished visiting Professor Andrew Napolitano, Judge Andrew Napolitano, and you'll see what I mean. And many months ago, Joel and Andrew conceived, and since then they've organized and worried to perfection today's incredible programming on the state of free speech and the future of the First Amendment. The thunderous and now often sharply divisive discourse of public discourse in communities, and campuses, and campaigns, and on communications channels of all kinds is reverberating throughout this country, and it demonstrates the worthy challenge that lies ahead for our presenters in this symposium. Now, the program led by our world-class faculty, including, and I'll mention her, Professor Beryl Jones-Wooden, who apparently broke an ankle and is unable to be here today, but was prepared to. Sabeel Rahman Khan, Miriam Baer, Nelson Tebbe, and our incomparable Vice Dean, who in addition to running all the academics here, is a first-class constitutional scholar in his own right. They, together with the learned and wise speakers you will hear from, are more than up to the task of addressing this critical issue. And they're, simply put, the speakers who are here, giants. Some are people I've had the pleasure and privilege of working with in the past. Others are those who I've admired and followed their work for many, many years. And I know you're really in for a very special and worthwhile session today. Today's program, to me, offers an extraordinary example of why it is that law schools and what they do matter. Law schools are centers for learning how to use the power of law to good effect in the service of people in society at home and abroad. That's a worthy mission. And it's why I deeply believe that notwithstanding the hypnotic, obsessive hold pseudoscientific rankings have over critics of law schools and the profession, we all can be justifiably proud of what we do to prepare new lawyers for the noble profession. And in this vein, it might be appropriate just at this moment to ask each and every one of you to reflect just for a minute on what prompted you to become a lawyer, and especially for our many students present, why you entered law school. This is on my mind particularly because last week news of Harper Lee's death transported me back in a Proustian memory flash to a childhood memory of a summer night looking up at a big screen at a drive-in movie theater on Route 110 in Melville, Long Island, and hearing the words, "Jean Louise, stand up, your father is passing." It's funny, to this day, I can barely say those words without choking up a little bit. I know it sounds hokey, but it just has that impact on me. And now for me, and I suspect for many others, Reverend Sykes' gentle admonition to Scout to pay some respect to her father and to kill a mockingbird provided that spark that ignited a lifelong passion for law. Now, of course, we've moved on from a time when the story of social and racial justice was told in stylized terms of a noble white man acting as the savior of blacks. And even my fictional Atticus is, to put it mildly, now more complex and has evolved. But the point is, and it's poignantly apt, I think, as we approach the end of Black History Month, which our students, as I said, have so effectively observed. The point is that each of us has our inspiration and worthy purposes leading us to legal careers, whether that motivation came from real-life legal heroes like Thurgood Marshall or Nelson Mandela, who most everybody knows was a great lawyer, or suffragette lawyers like some who graduated from this law school, or our parents, or my Atticus, or Perry Mason, whose Justice Sonia Sotomayor has written was her muse and inspiration, and she'll be visiting our students here Friday, April 8th. So students, don't forget to sign up Monday when that becomes possible. And it won't be like a rock concert. You'll be able to get in. But today we wrestle with the paradox of freedom. Now, freedom's not truly achievable by any single person existing on their own. And it's counterintuitive to think, but freedom actually requires self-restraint and tolerance. Even the ancient hermit, the castaway, the isolated mountain man of our Western lore were not truly free because they were prisoners of their daily routine to survive. By communing with others, the possibilities for freedom expands exponentially. It proliferates. Yet to be fully engaged with others demands restraint and tolerance because each of us are very different from each other. And so without some discipline, chaos ensues and freedom is lost, especially lost if the vacuum created by chaos creates a draw for government to intervene and, in worst case, for tyranny to take over. Remember that famous quote, which is one of the most famous misquotes in history, of Henry VI, Jack the Butcher: "First thing let's do, let's kill all the lawyers." What is overlooked when that's now become sort of a joke or a T-shirt kind of phrase is that Jack the Butcher was part of the mob, and he was bent on overtaking the established government and imposing tyranny, tyrannical rule. And so he knew that the first thing that he had to do was to get rid of all the lawyers because they were the guardians of law and the protectors of people. So this then brings us to the subject of freedom of speech. And speech, and indeed all communications, are meaningless and in fact impossible without involving other people. And for free speech to thrive, there must be, at some level, restraint and tolerance. And where that line should be, or how it judged and enforced, is what I expect we'll be considering throughout the promising day-long symposium, and I'm looking forward to it. It's my personal hope that this very important and exciting conversation we're going to have today is but one critically important step in demonstrating a much longer leadership and engagement on these issues for this institution that will be, in the long run, of some service to our democratic republic. Thank you all very much. And now it is my distinct pleasure to hand off to my friend of 46 plus years, Judge Andrew Napolitano, who has contributed in so many ways to this law school. It's a pleasure to have him on our faculty. It's bemusing to watch him on air, and it's great to have him as a friend. Andrew, please take over.
In the 5 minutes that are allotted to me, I want to address two problems. One is speech that the government hates and fears, and the other is forced speech. And when one thinks of speech that the government hates and fears, one thinks, at least I do, of the inimitable legal philosopher Lenny Bruce, who said, ready for this? If freedom of speech is the right to say the word fuck in public, then it's the right to say fuck the government in public. That, of course, is a phrase which, when extrapolated, the government hates and fears, much as King George hated and feared similar language, though expressed far more elegantly and eloquently than Lenny Bruce did when it was railed against him. And if you think of the things that the framers used as almost second nature to coalesce political forces on their side and against the king, it's language that would startle today. So here are some of the things that we pulled out. The spirit of resistance to government is so valuable that I wish it always to be kept alive. It will often be exercised when wrong, but better than to be wrong than not to be exercised at all. What country can preserve its liberties if its rulers are not warned from time to time that the people preserve the right of resistance? Let them take arms. The remedy is to set them right to facts. What difference does it make if blood is shed in the process? Now, these lines were used, of course, by a young Thomas Jefferson before he became president of the United States in the Revolutionary era, but it reminded me of some of the large rallies that we see on Fox News and elsewhere by the loudest of the Republican candidates for president, and I often wonder what would happen if Donald Trump called for violence, called for bloodshed in order to further his efforts to achieve the Republican nomination for president. Would the government intercede? We know the case law. We know it's Brandenburg. We know that all innocuous speech is absolutely protected, and all speech is innocuous when there is time for more speech to rebut and reject it. That indeed, a unanimous 1969 opinion underscores a core value of the First Amendment, which is that the remedy for hateful, offensive, abusive, harmful, revolutionary, destructive speech is not censorship, it is more speech. Even when the government doesn't like the speech, even when the government has the power to punish the speech, a power it should never have, because it should never be making judgments about what speech it likes and what speech it doesn't because of the First Amendment, which, as our late great friend Antonin Scalia said, no law means no law. And Hugo Black said the same thing. So I want you to think throughout the day of the language that we will use, not necessarily Lenny Bruce, but more likely Thomas Jefferson, and how that would play out of the mouths of politicians today and how the government would respond to it. Those of you who know me know my bias. My bias is that freedom comes from our humanity, whether you believe in an all-knowing or an all-loving God or not. It doesn't come from the government. We don't need a permission slip in order to articulate it, and that is nowhere more poignant, obvious, and ought to be the rule of the day than with respect to speech. The corollary of the freedom of speech, of course, is the freedom not to speak. That is an issue that will be played out in a California courtroom next week when Apple squares off against the Department of Justice. Ninth Circuit, in my view quite properly, has held that software is speech. Now, the Justice Department obtained a search warrant, which is the most unique search warrant I've ever seen in 42 years of examining search warrants, because it commands the FBI to seize and Apple to cough up something that does not exist, which basically means it commands Apple to create something that at the moment does not exist, which basically means it is commanding Apple to speak in ways that it chooses not to speak. And again, the argument is national security. Safety is always the argument. It's always the argument against liberty. It's the government's favorite argument. If you don't speak the way we want you to, if you don't remain silent when we want you to, then safety will collapse. There are many, many issues in the Apple case. Privacy is an issue. The ability of a private entity to regulate its extremely popular product is an issue. The proper role of government in our lives. Can the government conscript a person or a group against their will, or is that involuntary servitude? But let's not lose sight of the fact that speech is at the core of what we are looking at here, and speech is at the core of what the court will construe when the government moves to enforce this improvidently issued search warrant and Apple moves to quash it. This will probably make its way to the Supreme Court, which at the present time, of course, only has 8 members. The member who recently left the Supreme Court, and who's a good friend of some of us and a good friend of Brooklyn Law School, once commented that there is nothing novel about the proposition that the Constitution sometimes preserves the criminality of a few in order to protect the privacy of us all. There's nothing new about freedom trumping safety. It is indeed a value enshrined in the First Amendment, and without it, there would be a welcome mat for tyranny. My colleague who has organized all of this, who has put it together, who has done all the work, is one of the great defenders of freedom in the modern era. He single-handedly led the team that changed the nation's election laws so that more people could participate in the electoral process. And if you were at the wonderful program on the great Supreme Court opinion of Buckley v. Valeo, you had a chance to listen to him and to some of his now graying colleagues who worked on that great case. I won't tell you how many years ago it was. It's an utter joy to teach a course at a law school like this, where one of the great cases in the syllabus was argued by one of your colleagues. That colleague of mine and ours, Joel Gora.
Well, now you know why Judge Napolitano is a great judge and a great friend, and I thank you for that. I am Joel Gora. I teach here at the law school, and I helped organize this symposium, and I'm so pleased to see so many of our students here today, and I hope they'll be able to be with us for the entire program. For free speech, it is the best of times, and it is the worst of times. The Roberts Supreme Court may well have been the most speech-protective court in a generation, extending free speech protection on a number of fronts and rebutting claims by government to limit such protections. Yet those free speech rulings have drawn fire from critics both on and off the court, contending the decisions are inconsistent with democratic and egalitarian purposes of the First Amendment, and that they overprotect free speech at the expense of competing values. And in everyday life, censorship and suppression of speech seem more the rule than the exception, both at home and abroad. The Roberts Court turned 10 years old last month on January 30th, the 10th anniversary of when Associate Justice Samuel Alito joined the court, which Chief Justice Roberts had been appointed to a few months earlier. The resulting coalition of a 5-justice conservative majority, usually, has had a significant impact on the court's jurisprudence in a number of areas, especially evident in its First Amendment rulings. In my view, the Roberts Court may well be the most speech-protective court in a generation, if not in the nation's history, reaffirming and expanding powerful protection for free speech in a number of settings. In the process, the court has rebuffed numerous attempts by government to restrict free speech or to create new categories of non-speech. First, in a series of cases, the most well-known of which is Citizens United, based, as it was, on Buckley v. Valeo. Thank you, Judge Napolitano. The court has been insistent that protecting political speech is at the heart of the First Amendment's purposes in a democracy, and that limits on political spending are limits on political speech and can rarely be justified. The court's theory, echoing earlier rulings, is that government restrictions on how much can be spent to speak about politics and government and what individuals or groups can do, the spending and speaking, are fundamentally anathema to the essence of political freedom of speech and association. In these campaign finance cases, the court has also reaffirmed a theme that transcends politics, that another core purpose of the First Amendment is to guarantee that the people, not the government, get to determine what they want to say and how they want to say it, as Lenny Bruce reminded us. This liberty-affirming concept, which celebrates the autonomy of each person and group and condemns censorship of thought and speech by government, has application well beyond the political realm and guarantees the strongest protection to free speech in a number of settings, including protection for artistic, corporate, and commercial speech as well. In all of these areas, the Roberts Court has insisted that the First Amendment presumption against government censorship is but another recognition of individual and group freedom and liberty. Applying these principles, the court has steadfastly refused to declare speech that many deem socially worthless to be beyond the pale of the First Amendment's protection. In rejecting government efforts to criminalize depictions of animal cruelty, regulate the sale of violent video games to young people, punish those who lie about receiving military honors, and permit damages to the targets of even hateful and hurtful slurs and insults, the court has reaffirmed that it is the individual, not the government, who must judge the worth of each speech. In those cases, the court emphatically refused to expand the very short list of non-speech exceptions to First Amendment protection, such as obscenity and fighting words. To be sure, the Roberts Court has not invariably ruled in favor of free speech claims. It has allowed government in some circumstances to censor student speech, government employee speech, certain forms of campaign funding associated with elections to judicial office, and speech supporting terrorist organizations. It has also given government some leeway to control speech on or utilizing government's property. But these few exceptions help prove the rule, that outside of these few instances, I believe the Roberts Court has insisted on preserving the vital individual and societal First Amendment values served by affording the most rigorous protection to free speech. The same regard for the individual can be found in a number of significant cases where the court has protected religious freedom against the demands of government as well. But that Roberts Court, that mostly First Amendment-friendly Roberts Court, sadly died 2 weeks ago with the untimely death of Justice Antonin Scalia, who was a staunch supporter of many of the court's strongest First Amendment cases. As a result, there is now grave doubt as to whether the Supreme Court will continue to be the surprisingly powerful voice for free speech that it had become, and the future of free speech and the First Amendment may well hang in the balance. Indeed, dissenting justices and prominent legal scholars have suggested the Roberts Court had gone too far, had overprotected freedom of speech, had not properly taken account of and balanced the needs of government advanced to justify restrictions on speech. Other critics have written the court's free speech jurisprudence off as simply right-wing favoritism of the rich and the powerful, insisting instead that the First Amendment should mainly protect the deserving lonely pamphleteer or soapbox orator of an earlier era. Ironically, liberals who usually led the fight for free speech a generation ago are more likely to be leading the charge to restrict free speech today. The Roberts Court, however, steadfastly maintained that the First Amendment must be available to every person or group who would seek to exercise its rights and refuse to means-test free speech protection. In taking that position, the court relied on free speech themes sounded in earlier, more liberal eras of the court. And the loss of a powerful pro-free speech Supreme Court is troubling for one final reason. In a time when the court was affording more speech protection in its legal rulings than almost any predecessor court had done, in everyday life, these are trying times for free speech. Censorship seems to reign both at home and abroad in what sometimes seems to be a war on free speech. Whether it be the instantaneous condemnation and punishment of fraternity members for singing racially offensive lyrics at a social event, the brazen murder of journalists for producing anti-Muslim cartoons and commentary, or the canceling of celebrity contracts for making offensive remarks or expressing unpopular views, free speech in everyday life seems often under attack and in jeopardy. Enhanced by technology and going viral, one slip of the tongue caught on camera or recorder can ruin an individual's career or life prospects. Technology has also facilitated unprecedented surveillance of citizens, which can create a new form of chilling effect to suppress government criticism, and one of our panels will be addressing that issue. And too often, our campuses, rather than being sanctuaries of free speech, thought, and inquiry, are venues for suppression and censorship of hurtful ideas, and our first panel, a little later this morning, will be addressing those concerns. In the face of these various suppressions of speech, it is imperative, in my view, that at least where the law is concerned, the Supreme Court continues to make it quite clear that free speech must be the rule and government censorship the rare exception. And that's what brings us here today. Brooklyn Law School is so fortunate to have so many of the nation's leading First Amendment advocates and scholars here with us today to address these pressing issues as they play out in the areas of hate speech, money in speech, corporate and commercial speech, surveillance in speech, and with our final panel to consider the future of free speech. And on behalf of the school, I want to thank all of our program participants for being part of this event. and I'm especially grateful to those of our speakers who have been my personal and professional friends and colleagues for so many years. I also want to thank my Brooklyn Law School colleagues who have contributed so much to bringing this symposium about. I want to thank my friend Judge Napolitano for co-organizing it with me. I want to thank Dean Allard for his continued support and encouragement, for hosting a wonderful dinner last night for the panelists to enjoy. I also want to thank Linda Harvey and Liz Alper and all of the people on the events and promotion staff for making this a really a spectacular occasion for the law school. I want to thank the students from the Journal of Law and Policy, particularly David Inkelis, the Symposium editor, and to note that papers generated by this symposium will appear in a special Free Speech Symposium issue of the journal later in the year. Thanks to all of you. I also want to thank Lloyd Carew-Reed and Alan Volney and Juan Pastori and our crack IT team for getting all this stuff done so well and adding a great deal to our program. And finally, I can think of no better way to begin serious consideration of the future of the First Amendment than to hear keynote remarks from perhaps the country's most well-known and highly regarded First Amendment lawyer, Floyd Abrams. A longtime partner at Cahill, Gordon, and Reindel, the author of numerous books and articles about the First Amendment, counsel in many of the most important First Amendment landmark cases of the past 45 years, from the Pentagon Papers case in 1971 to the Citizens United decision in our time, a professor of First Amendment and media law at Yale and Columbia Law Schools. Few people have thought about the meaning and purpose of the First Amendment as carefully as he has, and few people have helped implement the guarantees of the First Amendment as effectively as he has. It is also my great good fortune to have worked with him on many of those cases and issues over the year. Ladies and gentlemen, Mr. Floyd Abrams.
Good morning, everyone. You all are honored by Joel's presence today and the work that Joel has done through the years as a teacher, scholar, advocate, and I'm glad to be here. I'm really especially glad to be here in light of the extraordinary assemblage here of First Amendment scholars and practitioners. One might even say, to coin a phrase, that this may well be the most extraordinary collection of First Amendment talent and knowledge that has ever been gathered at one time and place, except, if you remember, when Jefferson dined alone. We meet, of course, shortly after the death of Justice Scalia, and I thought I'd talk a little bit about him. On a personal level, I knew him as well, but no better, than a few drinks together, a few dinners, and a few letters exchanged might suggest. I do recall talking with him at Kennedy Airport once when both of us were about to fly to California to participate in some sort of panel. He checked in, I checked in after him. I was told my reservation had been canceled. There was no seat. I said, it can't have been canceled. I didn't cancel it. I have a seat. I have to go. I have to be there, etc. And I went on and on. They finally let me stay on the plane. Justice Scalia came in back of me and said, "You want to change your position on capital punishment?" Some years later, Nadine Strassen, who will be participating a little later today in one of your panels, and I were in London at the same time, and she invited me to join her and Justice Scalia in a few drinks after he had appeared before a panel there in which he told the mostly English participants that there really was no such thing as international law, and certainly no such thing that America had to follow, something he very much enjoyed saying and that his audience very much hated to hear. We started talking about First Amendment cases, and in particular a case called Hill versus Colorado, a 1990 case of the Supreme Court, which had affirmed over Justice Scalia's dissent a significant limitations on speech in areas around abortion clinics. All three of us, Nadine, myself, and Justice Scalia, agreed how terrible the majority opinion of Justice Stevens was and how terrific the dissenting opinion of Justice Scalia had been. He enjoyed the conversation. He sat with a cigar in one hand, a drink in the other, and he said, I'm really not so bad about the First Amendment. And he wasn't. I didn't agree with most of his views on other topics and some of his views on the First Amendment, but that is not exactly a standard that binds anyone else. I'll tell you this, when Justice Scalia was on your side in an argument you were making or in an opinion he wrote, you would be forever grateful. And sometimes in areas of law that you thought you knew, and certainly in areas that you didn't, you learned a lot from him. I want to cite one example which hardly involved the most momentous moment of his career, but which had a good deal to do with the changing of my own views in a significant area. The case was the court's 1990 ruling in Austin versus Michigan Chamber of Commerce, in which the six-person majority of the court joined an opinion of Justice Marshall sustaining the constitutionality of a Michigan law which barred corporation from using its corporate treasury funds for independent expenditures in support of candidates or in opposition to candidates. Justice Scalia's dissent in that case, from its first extraordinary words to the last, seemed to me then and now a thing of beauty, of power, of passion, and to me, of total persuasiveness. I thought I'd read to you a few paragraphs from it. The opinion began with three words that make the opinion stand out in the history of the court. His first words in his opinion were, quotation marks, "Attention, all citizens. To assure the fairness of elections by preventing the disproportionate expression of views of any single powerful group, your government has decided that the following association of persons shall be prohibited from speaking or writing in favor of any candidate." Then there was a blank that he left for you to fill in the names of the entities which would no longer be able to speak about this subject. He then went on to say this: in permitting Michigan to make private corporations the first object of this Orwellian announcement, the court today endorses the principle that too much speech is an evil that the Democratic majority can prescribe. I dissent because that principle is contrary to our case law and incompatible with the absolutely central truth of the First Amendment, that government cannot be trusted to assure, through censorship, the fairness of public debate. A later paragraph read this way: the court does not try to defend the proposition that independent advocacy poses a substantial risk of political corruption, as English speakers use that term. Rather, it asserts that that concept, which it defines as financial quid pro quo corruption, is really just a narrow subspecies of a hitherto unrecognized genus of political corruption. Michigan's regulation, quoting from Justice Marshall's opinion, aims at a different type of corruption in the political arena, the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political idea, end quote. Continuing with Justice Scalia, under this mode of analysis, virtually anything the court views as politically undesirable can be turned into political corruption by simply describing its effects as politically corrosive, which is close enough to corruptive to qualify. It is sad to think that the First Amendment will ultimately be brought down not by brute force, but by poetic metaphor. The opinion concluded with this peroration: the premise of our system is that there is no such thing as too much speech, that the people are not foolish but intelligent and will separate the wheat from the chaff. As conceded in Lincoln's aphorism about fooling all of the people some of the time, that premise will not invariably accord with reality, but it will assuredly do so much more frequently than the premise the court today embraces, that a healthy democratic system can survive the legislative power to prescribe how much political speech is too much, who may speak and who may not. Because today's decision is inconsistent with unrepudiated legal judgments of our court, but even more because it is incompatible with the unrepealable political wisdom of our First Amendment, I dissent. I think that's about as good as it gets in judicial rhetoric, and more important, in encapsulating the First Amendment. In fact, it's such a pleasure to read. I'll read a little bit more from a different case. In a much more recent case, Brown versus EMA, a case involving California limitations on juveniles buying violent or renting violent video games, Justice Scalia wrote the opinion for the court striking down the California statute. Justice Alito, in his dissenting opinion, had described at great length some of the violent video games, some of the excesses, the extraordinary excesses of some of the violent video games available for purchase. Here's how Justice Scalia dealt with that. Quote, Justice Alito has done considerable independent research, a very nice way to put down, this is to the students, therefore not in the briefs. He did it. Justice Alito has done considerable independent research to identify video games in which, quote, from Alito, the violence is astounding, victims are dismembered, decapitated, disemboweled, set on fire, and chopped into little pieces. Blood gushes, splatters, and pools, unquote, from Justice Alito. Justice Alito recounts all these disgusting video games in order to disgust us. But disgust is not a valid basis for restricting expression. And the same is true of Justice Alito's description of those video games he has discovered that have a racial or ethnic motive for their violence. Ethnic cleansing of African Americans, Latinos, or Jews. To what extent, to what purpose does he relate this? Does it somehow increase the aggressiveness that California wishes to suppress? Who knows? But it does arouse the reader's ire and the reader's desire to put an end to this horrible message. Thus, ironically, Justice Alito's argument highlights the precise danger posed by the California Act, that the ideas expressed by speech, whether by violence, by gore, or racism, and not its objective effects, may be the real reason for government prescription. I'll put aside the beauty of that writing, the lawyer's skill involved, the advocate's effort. Just think how powerful it is to deal with the horror show set forth in Justice Alito's opinion by pointing out persuasively that what it amounts to is concern about the ideas that stem from the awful excesses of the video games. We will miss someone who can write and think like this and who could defend the First Amendment so effectively. In Justice Scalia's honor, I thought I'd do a little bit of originalism for you today about the Bill of Rights in general and the First Amendment. in particular, which bear, I think, on the various topics that will be considered today. And I begin with two decisions made at the time of the drafting of the Constitution itself in Philadelphia in 1787. The first was one of tone. The writers of the Constitution, Madison and his colleagues, understood full well the difference between writing a Declaration of Independence and a Constitution that would succeed the Articles of Confederation that had created an alliance of entities freed from British rule, but not really functioning as a national government. In drafting the Constitution, the founders made no effort to match the grace or passion of Jefferson's glowing revolutionary rhetoric in the Declaration of Independence of the previous decade. No inalienable rights were referred to in the new document, no pans to human rights offered. The Constitution's language, as Clinton Rossiter has observed, was plain to the point of severity, frugal to the point of austerity, laconic to the point of aphorism. It was, in short, not a poem, but a blueprint, one devoted to establishing a new government and setting forth how it would work. And it had been agreed upon after what John Adams described as the greatest single effort of national deliberation that the world has ever seen. Madison's understandable satisfaction at the result is reflected in a letter he wrote to Jefferson, his friend and mentor, and then the U.S. ambassador, the first in France, which observed that it is, quote, impossible to consider the degree of concord which ultimately prevails as less than a miracle. One of the topics as to which there had been nearly complete accord was not to include a Bill of Rights in or with the Constitution. This was the second decision to which I referred, and to say the least, a major one of substance, although discussed by the framers much less than many other topics, the power of the president, how to set up electoral districts, and how to deal with slavery, and a wide range of other topics. But there was a vote on whether to have a Bill of Rights or not. And when the vote was taken, 10 states voted against it, none voted for it. The record of the Constitutional Convention reads this way, quote, on the question of a committee to prepare a Bill of Rights, New Hampshire, no. Massachusetts, absent. Connecticut, no. New Jersey, no. Pennsylvania, no. Delaware, no. Maryland, no. Virginia, no. North Carolina, no. South Carolina, no. Georgia, no. And when two delegates after that vote proposed a declaration stating, quote, that the liberty of the press shall be inviolably observed, unquote, Roger Sherman from Connecticut responded that since the power of Congress does not extend to the press, it was unnecessary to say that the press was protected against the government. And by a 7-4 vote, the convention rejected that motion. What may have seemed obvious enough to the delegates was far less so to others. Jefferson was personally appalled that the newly empowered national government would not be explicitly limited in its authority by specific prescriptions. It astonishes me, Jefferson wrote, that so many of our countrymen should be contented to live under a system which leaves to their government the power to take from them the trial by jury in civil cases, freedom of religion, freedom of press, and other rights. A Bill of Rights, he wrote to Madison, is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Another Jeffersonian letter stated that he had disapproved from the first moment the want of a Bill of Rights to guard against the legislative as well as the executive branches of the government. And so critics of the newly drafted Constitution addressing in the ratification time, when the states had to decide whether or not to adopt the Constitution, focused their fire on the absence of a Bill of Rights. Patrick Henry, opposing ratification before the Virginia legislature, said, "A Bill of Rights may be summed up in a few words. Why not use them?" Otherwise, Henry said, "the officers of Congress may come upon you, fortified with all the terrors of fortified federal authority." In South Carolina, James Lincoln complained that he would, quote, "like to know why there is a total silence in this Constitution with respect to freedom of the press. Was it forgotten? Impossible. Thus, it must have been purposely omitted, and with what design, good or bad, he left the world to judge. The liberty of the press," he said, "was the tyrant's scourge. It was the true friend and firmest supporter of civil liberty. Therefore, why pass it by in silence?" In New York, Cincinnatus, one of a number of anonymous critics of the newly drafted Constitution, said that, quote, "not only is some power given in the Constitution to restrain and even to subject the press, but it is a power totally unlimited and may certainly annihilate the freedom of the press." Responses from opponents of including a Bill of Rights offered views similar to that uttered by Sherman that I quoted a few minutes ago. Why Alexander Hamilton, not yet a musical comedy star, responded in much quoted questions he posed in Federalist 84. Why should the charter of the newly reorganized government declare that things should not be done which there is no power to do? Why, for instance, Hamilton wrote, should it be said that liberty of the press should not be restrained when no power is given by which such restrictions may be imposed? In fact, Hamilton argued the Constitution is itself, in every rational sense and to every useful purpose, and now in capital letters, a Bill of Rights. Similar themes were articulated by other supporters of the new Constitution. Where, Governor Randolph of Virginia said, is the page in the Constitution where freedom of the press is restrained? If there had been any regulation about it, leaving it insecure, there might be reason to have a Bill of Rights, but that is not the case. Show me, he said, where there is anything in the Constitution that says that freedom of the press may be limited. Others mocked the very notion of a Bill of Rights. Roger Sherman said, "No Bill of Rights has ever yet bound the supreme power longer than the honeymoon of a newly married couple." Noah Webster, tongue deeply in cheek, suggested that if it was a list of inalienable rights that was necessary, the Constitution should include a clause saying that everybody shall in good weather hunt on his own land and catch fish that are public property, and that Congress shall never restrain any inhabitant of America from eating and drinking at seasonable times to prevent his lying on his left side on a long winter's night. Madison had initially opposed the inclusion of a Bill of Rights, referring to it as a useless parchment barrier, which will never be regarded when opposed to the decided sense of the public. But confronted with political threats to his own election to the House of Representatives, in which his opponent and later successor as president, James Monroe, supported the inclusion of a Bill of Rights, Madison shifted his position from opponent to sponsor, and Madison wrote the first draft of a Bill of Rights and introduced it in the first Congress with the tepid assertion that given public concern about its absence, its inclusion offered something to gain, and if we proceed, nothing to lose. If we proceed with caution, nothing to lose. And as initially proposed in June 1789, the equivalent of what became the First Amendment's language about freedom of speech and of the press reads remarkably similar to what we have today, except in one respect. Madison's first proposal relating to freedom of expression submitted to the House was phrased this way, quote, "The people shall not be deprived or abridged of their right to speak or write or to publish their sentiments, and that freedom of the press, as one of the great bulwarks of liberty, shall be inviolable." By the time, on September 25th, 1789, the Senate had weighed in and the two houses had agreed on what became the First Amendment, it was couched, as we now know it, in a negative, an indelibly negative way. Congress shall make no law was chosen to introduce the First Amendment, a decision in turn that has led the Supreme Court through American history to rule that the First Amendment barred only governmental, not private, suppression of speech. What seems to me most striking today in reading those debates about the adoption of the Bill of Rights is that while there was fiery disagreement about whether to adopt such a document at all, little of it was about what those rights were. The debates all focused on whether it was necessary or even useful to have separate amendments or to include in the Constitution itself a list of rights rather than fleshing out the meaning of what those rights were. Now, inevitably, the language chosen has been subject to multiple, sometimes conflicting interpretations. And the passage of time has, of course, led to disputes that I think even Justice Scalia would agree would have been inconceivable in the 18th century. I mean, who can speak with confidence today about what the framers would have thought about net neutrality, video games, or algorithms? One view of the framer, however, could hardly be clearer. The great object of bills of rights, Madison observed when he first introduced it, was to limit and quantify the powers of government by accepting out of the grant of power those cases in which the government ought not to act or to act only in a particular mode. And later in the debate about the adoption of the Bill of Rights, Madison went farther. With its adoption, he said, "The right of freedom of speech is secured, the liberty of the press is expressly declared to be beyond the control, the reach of this government. The imposition of strict limits on governmental authority over religion, speech, and press was the central purpose of the First Amendment. It is what the First Amendment is about." In recent years, however, we have a new debate about what the First Amendment is about. Justice Breyer, in particular, has offered interpretations of the First Amendment that appear to me to be closer than those adopted in European nations in interpreting their more limited free speech protections under the European Convention on Human Rights. His opinions often conclude that First Amendment interests lie on both sides of a case, the side challenging government action and the side supporting it, thus neutralizing the First Amendment. They repeatedly seek to apply the concept of proportionality, whether, quote, a statute works speech-related harm that is out of proportion to its justifications, thus minimizing the First Amendment. And they consistently eschew any broad reading of the First Amendment. The result, unsurprisingly, is an undernourished First Amendment. In his book, Act of Liberty, Justice Breyer maintained that the primary purpose of the First Amendment goes beyond protecting the individual from government restraints. First and foremost, he wrote, the First Amendment seeks to facilitate democratic self-government. And correctly viewed, he argued, one must understand the First Amendment as seeking primarily to encourage the exchange of information and ideas which are necessary for citizens to shape that public opinion which is the final source of a government in a democratic state. And in his dissenting opinion, in the McCutcheon case dealing with limitations on contributions to candidates, an opinion in which he was joined by Justice Ginsburg, Sotomayor, and Kagan, Justice Breyer said this: "The First Amendment advances not only the individual's right to engage in political speech, but the public's interest in preserving a democratic order in which democratic speech in which collective speech matters." The First Amendment, he argued, must be understood as promoting a, quote, government where the laws reflect the very thoughts, views, ideas, and sentiments, the expression of which the First Amendment protects. In my view, all these articulations offer inversions of what the First Amendment is about. First and foremost, to use Justice Breyer's words, the First Amendment seeks to protect against the dangers of governmental overreaching. It is not about protecting or promoting collective speech, but avoiding the imposition of just that sort of speech by the government. One of the benefits of the First Amendment is surely that it generally leads to a better informed public and therefore a more representative government. But we surely would not allow speech to be suppressed because the government decided it led the public to become badly informed or less enamored of representative government. That sort of censorship is precisely the opposite of what the First Amendment is about. The notion that First Amendment interests are served whenever laws genuinely reflect what the public determines it favors also ignores the reality that the public too often seeks to suppress speech of which it disapproves. Speech is sometimes ugly, outrageous, even dangerous, and the public's reaction and response to such speech is often one of disgust, revulsion, even anger. Who would doubt that the collective speech of the public would likely result in the banning of virtual child pornography on the internet, lifelike depictions of children, not of real children, but of virtual children, that, as a federal statute provided, appeared to be of minors engaged in sexual conduct, a statute held unconstitutional by the court under the First Amendment because they were not films of real children? Or who would doubt that there were and are substantial majorities of the public that supported and would still support legislation held unconstitutional by the Supreme Court, with, among others, the vote of Justice Scalia, that banned the burning of the American flag, or that the public, inconsistently with the First Amendment as interpreted by the Supreme Court, would overwhelmingly support punishing or at least silencing members of the Westboro Baptist Church, whose contemptible practice it is to coarsely denounce American soldiers who have died in the defense of their country on the days of their funeral in a place as close to the churches in which they were being mourned as the police would allow. Chief Justice Roberts' response to the Breyer opinion seems to me cogent. He wrote, "The dissent's collective speech is, of course, the will of the majority, and plainly can include laws that restrict free speech. The whole point of the First Amendment is to afford individuals protection against such infringements. The First Amendment does not protect the government, even when the government purports to act through legislation creating collective speech." Finally, the First Amendment is obviously not the only liberty-protecting provision of the Bill of Rights. If it were, we would not need the other 9 amendments of the Bill of Rights or the post-Civil War amendments that ended slavery, required states to provide due process, and effectively subjected state governments to most of the same limitations on liberty that apply to the federal government. Unreasonable searches and seizures by federal and state governments are banned. Trials in both government entities must be fair. Cruel and unusual punishments in each are barred. What all of these limitations have in mind is not that they're about speech, but that they're all about limiting governmental abuse of power. So when we consider each of the topics today, ranging from hate speech to money in speech, from surveillance and to speech with respect to the future. I urge you to bear in mind this history. It doesn't answer every question, and to many it may not provide any answers at all, but it does offer a starting point, a sort of takeoff point from which we may proceed. Thank you all very much.
Thank you, Floyd Abrams, for that stirring presentation and defense of the First Amendment, and thank you for your much too generous remarks about me. I have one other thing I need to do now, and that is to amend my opening statement. I omitted some very important thank yous. Number one, to my friend and colleague, Vice Dean Bill Ariza, who late last night, when we found out that Professor Beryl Jones-Wooden had broken her ankle, was gracious enough to agree to be the moderator for our hate speech panel, which will start in just a moment. So thank you, Bill, for that. And thanks as well to my friend and colleague, Judge Napolitano, who at 8 o'clock this morning agreed to pinch hit for Nadine Strawson, who is suffering a severe bout of stomach flu. And she, as Professor Jones-Wooden, sends her deepest regrets that she can't be with us today, but she did provide us with the text of her remarks, and Judge Napolitano will be pinch hitting for Professor Strawson. So thank you, Bill, and thank you, Andy.